As Ryan said, I'm a philosopher, so that means I'm not a lawyer. And I'm going to focus on the issue of free speech, as I put it, the subhead here, as a political principle and as a right of the individual. I'm going to focus on some of the, I think one of the ways Ryan put it was underlying rationale about this principle. And I think it's when we think of this as a principle that's supposed to be embedded in American law, it's a very radical principle. And part of what I want to stress is how radical a principle it is if you really take it seriously. I have a manual quickly. I want to focus on three basic things. So I'm going to talk a little bit about the basic idea of freedom of speech and situating it in a wider philosophical context. So both about some of the foundational documents of the American system of government, but the wider way of thinking about freedom of speech. It's an aspect of intellectual freedom. And when you think of the Enlightenment period in the history of the West as what I think it's sort of the philosophical winds that are pushing to the creation of the United States of America, I think you have to think of the battle as wider than just about freedom of speech. It's about intellectual freedom. So I'm going to talk a little bit about that. And then about it as a political principle. And that as a principle, I think one should think about it as an absolute. And part of what it means that freedom of speech and wider intellectual freedom is an absolute, that one shouldn't think of it as having exceptions. I'm going to talk a little bit about that. I think that's part of what it means to think of it as a principle that's supposed to be embedded in the law. And then I want to highlight some of the radical implications of this principle, particularly the relationship with property rights and of thinking of what government should and should not be able to do in regard to intellectual freedom. And I'm going to compare it to the way that one thinks of religious freedom more narrowly, which I think of as an aspect of intellectual freedom. So that's what I'm going to do. I'm going to try to keep it to 30 minutes at maximum. So if you can, so the first element, just to remind us, click again, thank you. Two things. So the first, here's the full text of the First Amendment. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or of the right of the people to peaceably to assemble and to petition the government for a redress of grievances. So the First Amendment is more than just about freedom of speech or freedom of speech and freedom of the press. It's about religious freedom. It's about to assemble and to petition the government. And I think when one thinks of the total of this and of what the First Amendment is doing, you have to think of it as wider than just freedom of speech. And if you're asking what a common denominator is between freedom of speech or freedom of the press, freedom of religion, freedom to assemble, to petition the government, so it's sort of to argue with the government, it's about intellectual freedom. Not every aspect of intellectual freedom, but what the First Amendment is trying to protect is intellectual freedom. And if you think of the Bill of Rights as not trying to list exhaustively every right that the citizen possesses, it's not trying to be an exhaustive list of what intellectual freedom encompasses, but it's highlighting certain crucial aspects. And I'll talk a little bit about why I think some of these aspects are really being highlighted. And the sort of even the wider context in which to think of the First Amendment of the Bill of Rights is how rights were thought about at the time. And if you take the Declaration of Independence as the central and celebrated and rightly celebrated as enunciating the place of rights and thinking about government, to take the crucial excerpt from the Declaration, that we possess certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, and that the government's purpose is to secure these rights. Governments are instituted among men, deriving their just powers from the consent of the governed. And I think that if one thinks about the First Amendment, it's crucially about the issue of liberty. When you look at discussions at the time about rights, there's basically one right, a right to life, and it's broken up into liberty, property, and the pursuit of happiness. Now, property is not in the Declaration of independence, and I think that's a lot because of the issue of slavery, and they're grappling with that. But when you look at other writings around the time, it's these three, or they're often encompassed. These are the one's basic rights, and I think of them as one is about intellectual freedom, one is about economic freedom, and one is about moral freedom. To take the two that I'm not going to talk very much about, but the pursuit of happiness meant the pursuit of your own individual happiness, that you have a right to do that and to engage in the kinds of actions that you think are necessary to pursue your own happiness. And that's against being ordered by the government that you have to serve God or carry out God's will or God's word, or that you have to carry out sort of the social good or the good of the society, public good, the common good, a kind of utilitarian perspective. That comes later, I think, in the history of thought and into the 19th century. But I think it's important to get when they're talking about the rights and about the freedoms that they protect, it's very much in an individual context. So there's a lot of later justifications about freedom of speech, and if you take in philosophy, John Stuart Mill in the mid-19th century is the classic on liberty. It's very much we should permit the speech that's necessary for society to function well. And I think it's important to get that that's not the way they're thinking about it when they're thinking about the US form of government. It's about protecting the individual's freedom. And it's not, the individual's freedom is not a means to some end, whether God's will or society's will. That's a later idea, I think, in the history of philosophy. And property was about a freedom to produce, a freedom to engage in trade. And liberty, and that's where I want to focus on, intellectual freedom, meant a whole bunch of things, such as freedom of thought, freedom of speech, freedom to assemble and petition, freedom to associate with who you want to associate and not associate with people you don't want to associate with. And this was all a means of protecting a person that he can think for himself, form his own judgments, and then follow through in living his life by his own thoughts and his own judgments. And so what I think the First Amendment is doing is specifying crucial aspects of liberty or intellectual freedom and saying these are beyond the reach of government power. Indeed, what government power is supposed to be about is protecting these things, securing these things for the individual. And so I think that when you read the justifications for why we need freedom of thought, freedom of speech, intellectual freedom more broadly, they're an individual justification. So they're looking at it from the point of view of an individual. And that if you're really to pursue knowledge, or if you're to, as it will often be put in philosophy, to pursue what's true and what's good, you have to think for yourself. And that in a very deep way. I mean, what the Enlightenment was about the power of knowledge, and that everyone can pursue it and can reach it. Everyone can reach a state of enlightenment. And that you have a moral right to engage in that kind of activity. And to really think about things is you have to be free to discover, to learn, to advocate, to discuss ideas with people, to support the ideas that you think are right or good, to oppose and argue against the ideas that you think are wrong and even evil. Real thinking means you can't be on a leash. So someone can't pull back and say, no, I don't like the conclusion you're reaching, stop thinking about that. Nor can they close off the world to you and say, no, this you're not allowed to do, look into this, that's beyond the pale. That you're not really thinking. If someone else is controlling what you can look at, what counts as evident, what counts as reasonable view to entertain, and what doesn't count, you surrender your ability to think. If you surrender to some authority, in this case a government, the power to circumscribe. You know, you can't look at this. It's irrational, it's evil, don't consider it. And the view is not it's important to get this. The view is not that there's no such thing as irrational ideas or even evil ideas. But you have to figure that out, and you have to determine that. Like, I think there's a lot of irrational and evil ideas. Take one thing that people like to ban, Holocaust denial. and the books and the people who speak about this. I think there's nothing to it. There's no evidence for it. It's a conspiracy theory. It's very irrational, and it's evil. It does a lot of harm to the victims of the Holocaust. But you can't let someone else decide for you that that's how you should classify. You have to be able to think about it. And to be able to think about it, if you start to think, well, maybe there's something to it. Maybe it's essentially crazy, but maybe there's some grain of truth in it. You have to be able to look into that. You have to be able to discuss it. You have to be able to read it. And if you've given to the power to the government to cut that off, you can't do that. So you can't really think. And you can't really form a considered or a reasonable view. And so it's very much an individual justification. It's not about the effects on society and so on. It's if you are going to actually pursue the truth, this is what you have to be able to do. And then if you think in the context of, the architects of the American system and the whole Enlightenment thinking about government, they knew that, and they studied in depth that if you think of governments throughout history and traditionally, governments don't recognize this right. Indeed, they claim the power to control the thought and speech of the individual. And I mean, two classic examples that come up all the time in writings of the period are Socrates and Galileo. And these were people who, they're both discoverers of new knowledge, of new truth, that the government says, or the authorities at the time said, no, this is wrong, this is evil. Socrates is accused of corrupting the youth, and he's put to death. And the same as Galileo in regard to the church, like these ideas are beyond the pale. He's put under house arrest. The Enlightenment thinkers themselves, many are on the run, publishing anonymously because they're scared of publishing under their own name. They flee to other countries. And then, of course, the whole issue of religious dissenters and the religious wars in Europe. So they knew that governments claim this power all the time. So I think part of what the First Amendment, why it explicitly lists some of the things that it lists, is they know in the history of government, those things are often denied to the citizens, and the government says, no, you do not have a right to this. So if we're trying to really specify areas in which we know government is going to encroach on, or try to encroach on, that's part of why it lists. It doesn't list every form of intellectual freedom, but it lists crucial ways in which government has interfered. So that's a little bit of what I think the basic idea of the freedom of speech, of the First Amendment, and more broadly of what they're trying to secure and protect is intellectual freedom. And that if one's thinking of it as this is the principle that they're trying to inject at the base of government and how to think about government, and government is supposed to secure this, not violate this. That's the first point. The second point of thinking of it as a principle, if you really think of it, I think in the context of intellectual freedom and what it's trying to protect is the individual's own pursuit of what he thinks is true and what he thinks is good, and that he has to really be able to engage in deep thought and in deep investigation in order to do that. You will think of what freedom of speech and what the First Amendment is trying to protect in a way that it's a principle and it's an absolute. So it's crucially about that you decide which ideas you think are true, which ideas you think are good, which ideas you're going to advocate for, which ideas you're going to support, which ideas you're going to oppose. And you recognize that other individuals have exactly the same right as you. So you're not trying to silence them or tell, well, their views are beyond the pale, government should ban their views, not my views, but other people's. So you have a view, it's a principle that applies to everyone and has to be applied equally to everyone. It includes that people can walk away, so that if they don't like what you're saying, they don't like what you've written, they don't have to read it, they don't have to listen. So it crucially, if you're going to have this right to both support what you think is right and not support what you think is wrong, other people have to have the same kind of right. So there has to be the ability to walk away. And in terms of thinking about it as what is the government's interest in this area, and this is a kind of terminology that's often used when you read the people at the time, Jefferson, Madison. The government takes no cognizance of people's ideas or ideology. So it's not interested. There's no reason for it to investigate the ideas that people hold. So it's not trying to police ideas. It's not trying to decide what ideas are right, what ideas are wrong, what ideas are good, what ideas are evil. That's not its job. That's the job of you as an individual citizen to think about these issues. So it's not involved and it's not interested, or at least it shouldn't be. A proper government shouldn't be interested in this. If you think of freedom of thought and freedom of speech as it's enabling a person to do something, then you will also realize that there's all kinds of actions that involve speaking that are not essentially about trying to figure out what's true or what's good. It's not about discussion of ideas, investigation. It's not about persuasion. And it's right that the law takes a different view of these kinds of actions. So I put a few threats. So if I walk into a bank and I slip a note to the bank teller, this is a stick up, hand up all your cash over, when there were still cash in banks. If they hand it over to me, and let's say I don't even have a gun, and there are cases like this, all I brought in is a note, and they hand the money and I leave, and then I get arrested. You can't say it's not a defense. I was just talking. I was just talking to the teller. No, I've threatened, and it's not the teller's job to figure out, do I really have a gun or not when I've introduced a threat into the situation. I'm not letting the other person walk away, disagree. I mean, if he walks away, he's worried he's going to get a bullet in his back. That's a very different and it's not an exception to the issue of, well, okay, I guess in that case you don't have freedom of speech. The whole issue is it's not really about speech. It's about I've threatened someone, and I shouldn't be able to do that. And it doesn't matter what my ideas are. It doesn't matter if I'm a communist and I'm robbing a bank, I'm a Democrat or Republican, I believe in God, I don't believe in God, all that's irrelevant. So it's again, the government's not taking cognizance of the person's idea. What it's taking cognizance of, you started threatening people. And that is, you shouldn't be able to do that. And even if all you're using is words to threaten people, that doesn't matter. And that's not an exception to freedom of speech. And I think that there's similar kinds of things. If I incite violence, which is taken as a kind of standard case, well, that's an exception. If there's a kind of lynch mob forming, and I say, well, yeah, we should go get the guy, and he's over there, and so on. That again, it's not an issue if you think of what the freedom, so the sphere of action that they're trying to protect. It's not what they're trying to protect. And it's again, that's not a situation where you're discussing with the other person, you're trying to persuade him, you're not letting him walk away. The whole thing is you're inciting a gang to do, again, violence to him. It's similar in that sense to a threat. And that it involves talking, that the action of incitement involves talking, doesn't make it an exception to this if you're really thinking of like what the principle is and why we have this principle. And I mean, I'll leave aside criminal conspiracies. There are similar kinds of things, but the essential, I think, is when you're forming a principle, and particularly when you're thinking about rights, you're defining a sphere of action in which a person should be free, where he decides, and no one comes in and tells him what to do. And what freedom of speech, and more widely freedom of speech, freedom of thought, intellectual freedom, is trying to do that. And these things fall outside their sphere. They're not in it, but we make an exception for it. They don't fall in that sphere. And as a result, they should be treated differently, I think, in the law, as they are treated differently. Okay, so that's a little bit on the issue of it as a political principle, and thinking of it as a principle, and thinking of sort of what its scope is, and what it's protecting, and what it's not. The last issue of thinking of it as it's an individual right, to go back to that table of rights, it's one aspect of a person's right. There's basically one right, a right to life, and there's various aspects. And you have to think of freedom of speech in the context of other rights. And I want to especially emphasize two, property rights, and then thinking of it in relation to religious freedom, the issue of intellectual freedom more broadly. So freedom of speech as a right, the right to freedom of speech, can't mean that it gives you a right to use other people's property against their consent. Because then otherwise you've got one right that leads to the violation of another right. You're trying to get a view that all these rights you can exercise and anybody can exercise them. So the right to freedom of speech is a right. Like if you have some property, if you have a website or that you've purchased, you can put up there things that you want there. You can't go to Facebook or to YouTube or Twitter and say, look, I've got freedom of speech, so I should be able to use your platform how I want to use it. And I should be able to put up what I want to put up on that platform. Because if that's what your freedom of speech really encompassed, then they don't have a right to control their property. And indeed, in the end, it's a violation of their freedom of speech. And you can take these internet platforms, it's true, if you take a newspaper publisher, a publisher of books, if you're able to say, well, look, if you don't publish my things, that's a violation of my freedom of speech, then what intellectual freedom and then freedom of thought and freedom of speech is, you're supposed to be able to agree with the ideas you agree with, to disagree with the ones you disagree with, to be able to walk away, to oppose them, to not listen. It has to include to not publish, to not promote, and if that's their view, and even if it's for bad reasons, for their view of why they don't want to publish what you're writing or give you a platform, that has to be in the sphere of their rights. So freedom of speech can't mean that it gives you the right to other people's property, platforms, money, and so on. But similarly, it can't mean that it gives you a right to interfere with other people's property. So it's not a violation of my freedom of speech if 2 a.m. I'm blaring music or I'm listening to some talk radio in my neighborhood and I wake up everybody. I can't say, well, but look, I'm exercising my freedom of speech. Why? It has to be that people can not listen. And if I'm blaring it in 2 a.m, that's exactly what I'm not allowing people to do. So in thinking of it as a right, you have to think of it in the context of the other rights, and in particular in regard to property right. And there's so much. Now, I think there's various complications in regard to YouTube and Facebook, but there's all kinds of discussions now that it's a violation of freedom of speech if they deplatform people. And it is not, in essence, I don't think it is. So there's complicating issues in regard to that. And the last, and I think in a certain way, the most radical perspective on the issue of freedom of speech and of thinking of it and in the wider context about freedom of thought and intellectual freedom is it really means that the government should not be promoting or penalizing anything in the field of ideas, which is I think the model for this is the way that religious freedom is thought about and the way that it's formulated in the First Amendment. So that the religious clauses are usually broken up to, there's the Establishment Clause, the Free Exercise Clause. The Establishment Clause, Congress shall make no law respecting an establishment of religion. What that is trying to get at is the government's not in the job of promoting, however small, whether it's just one display of some religious symbol somewhere, it's not supposed to be doing that. So it's not promoting any particular citizen's religious ideas. That's the part of what the establishment, and when you read about Jefferson and Madison, for instance, of what they considered as breaches of that, it really is, however small, this is not the function of government. And the Free Exercise Clause is that Congress shall not prohibit the free exercise of religion. It can't penalize, again, however small, any individual who's peacefully practicing his religious ideas. But religious freedom is just one aspect of freedom and of intellectual freedom. It's singled out, I think, or it's not the only thing in the First Amendment, but it's highlighted in the First Amendment because if you think of the whole history of the kind of religious persecutions and wars in Europe, they're trying to say that we're not going to have this in the US. There's a real reason to highlight this, but it pertains to any ideas. And if you're thinking like freedom of speech is not freedom of religious speech, it's about freedom of speech. And as I said, I think you have to read the First Amendment as about intellectual freedom. If the government's not to promote or penalize, or another way it will often be put, it's not to pick winners and losers. That's true across the intellectual world, I think. So this is the last point. And this was Rand's perspective on intellectual freedom, which I think is right. That the government is prohibited from promoting or penalizing any ideas. And that means there's all kinds of activities today that the government is engaged in that are a violation of intellectual freedom. And a good way to think about that is if they were doing it in the realm of the religious ideas, it would be thought of as it's violating religious freedom. So public schools and universities, if it was establishing religious schools and universities, that would be considered, well, that's clearly a violation. Student loans and scholarships, that yeah, you're worthy of going to study and you're not worthy of going to study. Subsidies and funding for the sciences, for the arts, and so on. All of this is government picking, you can put it picking winners or losers, or promoting and penalizing ideas. And if you're really taking intellectual freedom seriously, and if you think of the religious clauses as a model for what it looks like to take it seriously, all this kind of activity is not actually, it's a violation of rights rather than the securing of rights. If you're thinking really deeply, I think, about intellectual freedom. And I've written some, this is the last slide, I've written some things, here's 2 books in which I have essays that touch in deeper ways on some of these issues. But that's so 3 points, to think about the freedom of speech in the wider context of intellectual freedom, of thinking of it as a principle, and of thinking of it, it has very radical implications. Just as this whole separation of church and state was a radical new idea at the time of the founding of America. If you think a little bit more broadly, it's what the US system is trying to do is separate government from the world of the intellect, that's the citizen's responsibility, not the government's responsibility. And that has radical implications for thinking about what is proper activity on the part of the government and what isn't. Okay, let me stop there.
Now we'll open it up if anybody has any questions for Dr. Ghate and Professor Hasnas about anything they talked about. Start back here.
I have a quick question. So in your presentation, you discussed how the First Amendment, sorry, I don't really know.
Onkar.
I don't want to check around, so. You discussed how First Amendment really protects intellectual property. How do you mesh that understanding with the IP clause of the Constitution, where you are picking winners and losers, you are picking people who get to have a patent, which creates economic incentives? How would you combine those 2 ideas?
I don't think of the issue of intellectual property as picking winners and losers. I think of it as what the government's job is to register this new invention, or we're talking about patents, device as property. So it's similar to when they're going into the West and the government is saying, okay, we recognize that now you have ownership of this piece of land. I think the best way of thinking about it is not the government owned it and now it's selling. It's rather recognizing you now, because actions you've taken, you've started to farm and you fenced it off, you have property in this. And I do think the issue of intellect, there is such a thing as intellectual property. And the person Thomas Edison, who invents these things, should have property in it. But they're not picking Edison as the winner and someone else as the loser. They're rather recognizing, yeah, you've created this property and now you're going to be secure in its possession. So I think that's very different than the issue of picking winners and losers comes up a lot when there's recessions. In the last financial crisis, they bail out this company, they let this company fold. So that's, I think, very different. That's what picking winners and losers looks like, I think, and that's very different.
So I think this question straddles the philosophical and the practical, so if you would like to answer, that'd be great. What do we do in a world where now speech is more and more described as violence, or merely offensive speech is described as, intimidating, or personally degrading? Where do we go at this point? Is it just a matter of we need more people studying philosophy, or do we need better laws? You just have to keep plowing forward with more speech. And is the answer to, is it to just lean towards allowing, just everything, or to start really picking through, different ideas?
So I think there's at least two things that need to be done. So one is you need to clearly distinguish between what really is speech and what is the beginnings of coercion. So there is I brought the issue of threats, and a person can make a threat without even brandishing a gun or a knife. And in a certain context, it really is the threat that, okay, now you're going to use coercion against me. You're going to force me against my will. And I have a very low tolerance for threats, and including online threats. I think the law should treat this is the beginnings of coercion, and it should be treated as you've introduced a knife into what was an argument. Versus there is speech that is degrading, insulting, and so on. I work at the Ayn Rand Institute. Ayn Rand, we're insulted almost every day. Your ideas are crazy. How could you advocate? But I'm not worried that someone's going to come and beat me up. And that is what freedom in the First Amendment is about. I cannot listen to this stuff. I can argue against it. What these views are all wrong. So I'm not worried about being beaten up, and you have to have a thick skin in that regard. And if I know that we're advocating unpopular ideas, of course there's going to be people who makes it uncomfortable. Some people will listen, some people will attack us, some people will smear us. This is what a debate about ideas looks like. And if you have if you really separate out real threats from insults where they're basically saying you're an idiot or you're immoral or something, but they're not going to try to kill you, then you have the idea that we have to police insults. When you've separated out threats, I think that is very, very dangerous. You can't have real discussion, real debate, a real contest of ideas if you can't say, look, I think your idea is wrong, and indeed I think it's evil if it was implemented. You have to, I think a lot of ideas are evil. Communism, for instance, and I had teachers as communists who I thought it's all wrong, and I actually think that what you're doing is evil, but you should be free to do it. That separation, I think, is really important.
Supporting freedom is always difficult and costly. And the reason is because human beings have limited knowledge. We don't know what the right answer is ahead of time. One of the arguments for freedom is we learn through trial and error. We learn by trying something and seeing if it works and adjusting our behavior. We learn through this process. With regard to matters of suppressing expression, if you can figure out some way of keeping the politicians out, you can keep the politicians out, if you can keep people out who can make rules that cut off the learning process, then it's up to us, right? I think that speech is not violence. I should be telling people why I believe that and trying to convince them of that. There is an ongoing debate in the academic setting about how much offense we should have to tolerate and what kind of offense should be suppressed. And if we talk about it long enough, we may successfully learn and work out some rules. It's hard for the people who are advocating open expression because people just want an answer. They want an answer now, and saying, well, you have to tolerate some bad things in order to preserve your freedom is a more difficult argument to make. It's like that for everything. It's our job to make the argument as well as we can, whether we win or lose. The trick is to make it so that we have the discussion and you keep the politicians out long enough so we can learn how to put the interests together in a way that allow people to cooperate and move on.
I wonder if you could flesh out a little bit more these, the Holocaust denier comment stuff that you talked about earlier. I spent last semester with CTLS in London, and this was really a big topic of discussion there. And particularly in Germany, which I know they have the baggage of the Holocaust, but still, I think, if I understand it right, that they base this restriction on the human right to dignity. But what I'm having a hard time understanding is how can this human right to dignity exist without the intellectual rights that you're talking about? And I wonder if you could just flesh that out a little bit.
Yeah, I mean, I'm Canadian, as it was brought up in the bio, and we have Holocaust denial laws as well, and it was a big issue when I was still living in Canada. I don't think there's a human right to dignity. So there's a right that to be treated by the government and by the whole legal system as a free and equal citizen. So something like Jim Crow, so if you think of that as, well, it's denying the dignity to the whole class of citizens. That's true, but it's doing it through the legal system. And the legal system has to view everyone as individuals and equal. But you can't go from that to everyone in society has to respect everybody else and treat them with dignity. No, if you think that what people are doing is really wrong and really evil, you should be able to treat them as, look, what you're engaged in is undignified, and I'm going to treat you as though this, like what you're advocating is monstrous, and you have to be able to do that. So if the government treats it as there's a right to dignity, it's incompatible with people's intellectual freedom, because now but I don't view you as, given what you've done with yourself and with your life and what you're advocating and how you live, I don't respect you anymore. And you can't either, I mean, you're not even supposed to really entertain that thought, but you certainly can't express it. So I think it's just a contradiction.
Can I just say that your point is the problem, is you hit the problem point in the following way. People tend to see the government's job as protecting rights. If it's the government's job to protect rights, now you have force being introduced in order to make sure we get things right, that rights are respected. And then what we have is a political struggle over what the rights are and how much power the government should have. You know, the way when I have the slides up, there's no power given to the national government to protect any rights of free speech. The First Amendment says, here's what the government can't do. It means that's left to us to figure out for ourselves. If you say it's the job of the government to protect the right to dignity, the right to this, the right to something else, all you've done is create a power struggle in which people are fighting back and forth to restrain others' behavior, which is not a good, not a good method of creating a free society. What you want to do is say, it's not the government's business to protect our rights. That's for us. The government is the entity that can infringe our rights. What we have to do is restrict its power.
You guys give me a couple more
Yeah,
questions?
I'm fine.
Okay, we're out of time, so if you need to go, feel free, but otherwise we have plenty of
Yeah,
questions.
there's no way we get through rush hour traffic anyway. I can stay.
You've had your hand up for a while. Yep.
I was hoping you'd flesh out your assertion that these online platforms, there's no role for free speech analysis in them. You dismiss that as saying that these are for private grounds, and so you can maybe categorically exclude people, and that's fine. And, I find that very unsatisfying. For one, I'm not sure what the extent of the property interest in when it exists on infrastructure created and maintained by the state. And then secondly, given that these platforms are used as and have displaced public commons, and that major public affairs are conducted on Twitter, it just doesn't seem like a very satisfying answer to just describe it as private property and then not grapple with free speech implications.
Yeah, I mean, my view of their creation, it's true, there's been a lot of government funding of science and some basic science and computer tech, but I think of Facebook, for instance, as it's essentially a private creation. I mean, almost any private thing now, you can find it somewhere in the history of it, there's been government involvement in it, but I still think of it as essentially private. And I don't think there's such a thing as the public commons. So you're individual citizens, and it's your responsibility to create the resources. If you want to speak and if you want to get your ideas out there, it's your responsibility to create the resources, either by yourself or trading with other people, to create microphones, to create newspapers, to create your own platforms. The idea that the government supplies a kind of commons where everyone can speak, that I think is a myth. And this is the issue with public universities. A public university, by its very nature, has to make content decisions. It decides these are the faculty who are going to teach, this is what the curriculum is. And to view it as sort of like it's a free-for-all where there's free expression, someone has to decide. And if it's not private citizens, it's the government deciding those kinds of questions. And that's why I think of it as it's an interference with intellectual freedom. So I think the whole idea of a public commons, there's some space where anybody can say anything, and now Facebook is taking that away from people. There is no such thing, and there could not be. There's literally no place where anyone and everyone could say everything on their mind.
Maybe a brief follow-up. There's a lot of concern of consolidation among these platforms. And so when there is only one platform and this is the only meaningful way to engage in society, what's the meaningful difference between the government restricting speech and this essentially private government forbidding speech? That seems like a distinction without a difference.
Yeah, I think it's a major distinction, and I think so these kind of antitrust arguments against, they're too big, they have too much control. And so this is a whole other issue, but I think all those antitrust arguments are wrong. And when you look at the history, I mean, this is the accusation against Microsoft, it's an accusation against IBM, and it's, you get competitors. If people really get fed up with Facebook or Twitter because of the way both their terms of use and the way that they're enforcing those terms of use, and if people think it's very biased how they're doing it, and they're not, like their terms of use are sort of lip service, but that's not actually what they're doing. Like a Sam Harris who left Patreon because he thinks they say they're kicking off people for reason X, but I really think it's reason Y. I'm not going to subject my whole income stream to this kind of capricious decision, so I'm going somewhere else. Or you have like a Jordan Peterson who's trying to set up his own platform. That is what freedom allows. And if people really do get fed up with it, you will get competitors springing up and quickly, and they will grow in the way that Google grew or Apple grew against Microsoft. So I think I know those antitrust things, but I don't think they're right.
Do you think that it's concerning that there's sort of this cabbage industry being developed around regulating speech, and sort of like you'll see corporations in particular hire whole, departments to just handle and regulate the speech of their employees within the actual department? And I think this is like a concern that I've heard of, not just in big law, but also at larger corporations like Google, like Yahoo, where you do actually have entire groups of people who are just there to regulate the speech of the employees within the corporation. And so I think we are talking obviously about the public sector, we're not talking about the private sector, but I think the private sector, they actually, you have I'm thinking of CEOs and different people within the C-suite who feel sort of beholden to these officers who come in and they're going to clean up the corporate culture, and clean up the corporate culture means, basically just over-regulate the speech of the employees to the point that it's suffocating. I don't know if you could speak to sort of the private sector regulation of speech, and I'm not talking about platforms, but I'm talking about within the office setting where we will end up spending, anywhere from a third to 2/3 of our lives. So
I don't want to monopolize it. This is a big deal to me.
Yeah.
Right? If you want to be afraid of something, here's what you should be afraid of. The government is always a much less efficient oppressor and regulator than the underlying system of tort law. Tort law is what regulates everything. That's what we're afraid of, right? What you should be afraid of is the government passing rules and then saying, we're not going to enforce them ourselves.
Right.
We're going to have private attorneys allowed to bring lawsuits to enforce the political rules. So if you create, the rules on sexual harassment are part of the Civil Rights Act as interpreted. So these are statutory creations. In tort law, we do the intentional infliction of emotional distress. Nobody likes it because it's too hard to litigate it. You have to do something really horrible for there to be liability. So since people are upset, that others can do all these horrible, offensive things. We just pass laws that say, okay, now it's a lot easier to shut people up or to stop people from saying things, and then we allow individuals to sue for that. And as a result, look at the way businesses behave. Businesses don't care. They don't want to win lawsuits. They want to never be sued because the cost of being sued is what all the expense is. So all of us, I don't know if you have to do it, but we here, every year we got to go through this system where we answer all of the questions and we can't get out of it. Right? All of the rules that govern our behavior and restrict what we can say is to make it so that the university doesn't get sued because we do something stupid. And we have to be on guard about what we say. That's what you want to be afraid of. I mean, because of the changing culture and social mores, I believe that we would have got continually more protection for people from offense. We're so secure physically now that pretty soon we'll get people's feelings get more and more protected. That's the way the tort system was going. We'd have more, but nothing like what you have now, because if a statute, sort of my rule of thumb, if a statute exists, that tells you what the common law didn't do. The only reason why any statute is passed is because that regulation didn't come about from people actually settling lawsuits.
Yeah.
The intentional infliction of emotional distress wasn't evolving fast enough. We got harassment law, and now, there's no limit to how far you will push it. Nobody's safe doing anything in the private sphere because they're afraid of lawsuits. The regulatory power is private lawyers, and the creation of these private suits by politicians is what is really oppressive. That's what we should be afraid of.
Thank you.
I think, again, you need to distinguish the two things. A company has a real interest in setting the terms of operation within it. And I don't think of this as an issue of free speech, but I'm at an organization. You don't want meetings where anyone can just say anything, 4-letter words against the other people who they are. So you set terms of conduct. It's not about freedom of speech. It's just this is how our business is going to operate. And Facebook and Twitter and YouTube, they really have to think about this. And what do we want to allow on our platform? And if we're going to try to eliminate some things, how do we do it in a way that makes sense? And it's not, if we're doing it by AI and so on, that we really think it's removing the stuff that we want removed and not. It's very complicated to run this. And then if you have the political intruding on that, and I think when Zuckerberg was dragged in front of Congress, that's what's happening. They face, and if they're halfway decent people, do they want ISIS using their platforms and things? No, but to figure out ways that you can stop that without harming innocent people and so on is difficult. And then if you have the political saying, if you don't, in effect, I think the hearings are, if you don't do it in a way we like, we're going to pass laws against you and make you do things. And that, then you can no longer figure out, and it's hard for the business person to know, am I doing this because I think it's the right thing to do, it's the right terms of service, or am I doing it because I'm worried if I don't do it, government's going to pass some law, some statute that will make me do it. And and the First Amendment is supposed to say the government can't do this.
The reason I was asking is because it just seems like when you brought up the new sort of what they're doing to the Georgetown law, constitution, or whatever, or the regulations that they're having around harassment, that would be, I feel like, very practical at a place like Google or at a place like Yahoo, because I think they had a piece in the Wall Street Journal about the chilling effect that's taking place in corporate culture. And given that we spend so much of our lives immersed in corporate culture, it's a reasonable question, I think, to ask. Yeah, we have the public sector, but we also have the private sector, and there's really no sort of limitation on how far the private sector can go in terms of chilling speech and quelling dissent, because people's jobs are on the line.
We're not disagreeing.
Yeah.
Right.
If things were private, different organizations would limit the speech of the people involved to different degrees. There would be all kinds of different things, and some would be restrictive. The reason why you're seeing it across the board is because fear of lawsuit, given the universal rule that everybody has to subscribe to. And that means you don't have the differentiation, you don't have the difference.
Right.